Welcome to the next part of the topic. The next part is about PIL. The Supreme Court walked into every Indian's life. Welcome to the next part. Here we'll talk about PIL first. Imagine waking up one morning in a remote village. You cannot afford a lawyer. You have never visited Delhi. You have never entered a courtroom. You don't know what Article 32 means. You have never seen the Supreme Court building, yet a judgment delivered by the Supreme Court changes your life. Your child gains access to education, a bonded laborer is released, a polluted river is cleaned, a prisoner receives legal aid, a woman subjected to workplace harassment gains legal protection, and under trial, prisoner finally receives justice after spending years in jail. How is that possible? How can the Supreme Court decide cases involving people who never filed a petition? The answer lies in one revolutionary idea, an idea that transformed the court from a constitutional referee into a constitutional institution that would actively reach society itself. That idea is called public interest litigation, or simply PIL. If Keshananda Bharati between Parliament and the Constitution, PIL changed the relationship between the Supreme Court and the people. And once that happened, politics itself would never remain outside the courtroom again. Let's talk about the old Supreme Court. Before the 1970s, the Supreme Court largely functioned like constitutional courts elsewhere. Someone's legal rights had to be violated. That person approached the court. The court decided the dispute. The case ended. This system worked reasonably well for people who possessed resources. People who could hire lawyers, travel to Delhi, prepare documents, and legal procedures. But now imagine a bonded laborer, or a child working in a factory, or an under trial prisoner locked inside a jail for 10 years without trial, or a tribal community displaced from ancestral land. Could they realistically approach the Supreme Court? Usually not. The Constitution promised justice. Reality often denied access to that justice. The court slowly recognized this contradiction. Now let's discuss a question that changed everything. After the emergency, some judges began asking an uncomfortable truth or question: what good are fundamental rights if the poorest citizen cannot enforce them? Think about it. A right exists only if it can actually be exercised. Suppose the Constitution guarantees equality, but poverty prevents you from entering a courtroom. Do you truly possess that right? Or is it merely theoretical? The judiciary concluded that constitutional justice could not remain available only to the educated, the wealthy, or the politically connected. Access to justice itself had become a constitutional issue. This realization fundamentally changed judicial thinking. Two judges became closely associated with this transformation: Justice P.N. Bhagwati, Justice V.R. Krishna Iyer. Their constitutional philosophy was simple but revolutionary. The court should not remain passive when fundamental rights are systematically violated. Instead, constitutional procedure should adopt or adapt to constitutional purpose. This meant relaxing traditional procedural rules. Letters could sometimes be treated as petitions. Journalistic reports could trigger judicial scrutiny. Social activists could approach the court on behalf of marginalized communities. This was extraordinary. Imagine writing a letter describing inhuman prison conditions, and the Supreme Court treating the letter as constitutional litigation. That has actually happened. The court was no longer waiting for justice to arrive, it was reaching toward injustice itself. Critics often describe PIL as judicial innovation. That is true, but there was also constitutional logic behind it. Article 32 gives every citizen the right to approach the Supreme Court for enforcement of fundamental rights. Dr. B.R. Ambedkar famously described Article 32 as the heart and soul of the Constitution. The judges asked themselves, if Article 32 is truly heart of the Constitution, should procedural technicalities prevent that heart from functioning? The answer was no. Substance should prevail over procedure. Justice should prevail over formality. Constitutional rights should not depend entirely upon economic privilege. That philosophy reshaped Indian constitutional law. The transformation did not happen through one judgment. It happened through many. Take Hussainara Khatun versus State of Bihar. The court learned that thousands of under-trial prisoners had remained in jail for years without trial. Some had spent years in prison awaiting trial and the maximum sentence for the alleged offence. The court declared that the right to a speedy trial forms part of Article 21. Suddenly, constitutional liberty became far more meaningful. Then came Bandhwa Mukti Morcha versus Union of India. Bonded labor. Despite constitutional guarantees continued to exist, the Supreme Court intervened. The Constitution entered places where exploitation had survived for generations. Then Olga Tellis versus Bombay Municipal Corporation. The court held that right to livelihood is an integral facet of the right to life under Article 21. This was remarkable. Article 21 originally contained only a few words. No person shall be deprived of his life or personal liberty except according to procedure established by law. Through constitutional interpretation, those few words gradually expanded into one of the richest sources of human rights jurisprudence anywhere in the democratic world. Here is an astonishing fact. If you had asked a constitutional lawyer in 1950 what Article 21 protected, the answer would have been relatively narrow. Today, Article 21 includes principles relating to human dignity, privacy, legal aid, clean environment, shelter, education in specific constitutional context, medical care, speedy trial, protection against custodial violence, prisoner rights, fair procedure, livelihood, rehabilitation. The list continues growing. How did one constitutional provision become so expansive? Because the Supreme Court increasingly viewed the Constitution as a living document, not because its words changed, but because society changed. The court believed constitutional principles must remain capable of addressing new forms of injustice. Supporters celebrated this evolution. Critics warned that judges were entering policy making. The debate had begun. As PIL expanded, the nature of cases also changed. The court heard matters relating to environmental protection, river pollution, industrial safety, forest conservation, food distribution, police reforms, election transparency, corruption, prison administration, sexual harassment at workplaces, urban planning, mining, waste management, road safety, administrative accountability. Increasingly, the court was no longer deciding disputes between two private parties. It was supervising governance itself. For some citizens, this was inspiring, for others, deeply troubling. Because a difficult constitutional question emerged. When does judicial protection begin? Judicial administration. Let's examine the criticism honestly. Opponents of expansive PIL argued that judges possess constitutional expertise, not administrative expertise. Running government required budgeting, policy choices, technical knowledge, political accountability. Courts possess none of these democratic tools. If judges begin supervising road construction, garbage collection, air pollution, school management, or executive appointments, are they still interpreting the Constitution or are they gradually performing executive functions? This criticism became known as the debate over judicial activism versus judicial overreach. Notice something important. Neither side rejected constitutional governance. They disagreed about institutional boundaries. Voters argued inactive courts permit constitutional injustice. Critics argued overactive courts weaken democratic accountability. The Constitution itself does not provide easy answers. Every generation continues debating the proper balance. This transformation produced an unexpected political consequence. Once PIL demonstrated that constitutional courts could influence public policy, political actors adapted. Opposition parties increasingly approached the Supreme Court. Civil society organizations filed constitutional challenges. Governments sought judicial validation. Election disputes became constitutional disputes. Administrative controversies became constitutional controversies. Questions that earlier ended in ministries or legislatures now frequently ended before the constitutional benches. This was not because politicians suddenly became more litigious. It was because constitutional litigation had become strategically significant. Winning public opinion remained important. Winning constitutional legitimacy became equally important. That is why modern political strategy increasingly includes legal strategy. Every major political party now maintains sophisticated legal teams. Senior constitutional lawyers became central figures during political crises. Courtroom arguments began influencing political narratives. Politics and constitutional litigation had become permanently intertwined. Think about the court's position today. When Parliament passes a controversial law, citizens ask, will it survive constitutional challenge? When a governor acts during a hung assembly, everyone asks, what will the Supreme Court say? When elections produce constitutional uncertainty, attention shifts toward court number one. This was not the constitutional reality envisioned in 1950. It evolved slowly, judgment by judgment, doctrine by doctrine, crisis by crisis. The Supreme Court became something unique, not merely the highest court, but the Republic's constitutional conscience. Whether one welcomes that transformation or questions it, its political consequences are impossible to ignore. By the 1990s, the Supreme Court had become one of the most influential constitutional institutions in India, but another conflict was quietly developing. Not between citizens and the state, not between Parliament and the court, between the executive and the judiciary themselves. Who should appoint judges? Should elected governments possess the decisive voice, or should judges appoint judges? That institutional struggle would produce another constitutional, unlike almost anything else in the democratic world, a doctrine that continues shaping every constitutional controversy in India. Because before the Supreme Court can decide political crisis, someone must first decide who becomes a Supreme Court judge. That battle would become one of the most consequential constitutional conflicts in the history of the Republic. Next part of this lecture is who controls the judges. The hidden constitutional war between judiciary and the executive. Imagine this scenario. The Prime Minister wins a historical election. His party commands an overwhelming majority in Parliament. The cabinet controls the executive. The government drafts legislation. It influences national policy. It shapes India's economic direction. Yet, there remains one institution that the government cannot simply command. Now ask yourself a simple question. If the Supreme Court can invalidate government action, who decides who becomes a Supreme Court judge? At first glance, this appears to be an administrative question. It isn't. It is one of the most important constitutional questions in any democracy, because whoever influences judicial appointments eventually, and whoever influences constitutional interpretation, indirectly influences the limits of governmental power. This is where the constitutional law stops being abstract and becomes institutional strategy. What was the founders' expectation? When the constitution was drafted, the framers did not expect judicial appointments to become a constitutional battlefield. Article 124 appears straightforward. Judges of the Supreme Court would be appointed by the President. The President would consult constitutional authorities, including the Chief Justice of India. Notice the word carefully. Consultation, not concurrence, not approval, consultation. For decades, this arrangement appeared relatively uncontroversial. The executive appointed judges, the judiciary advised. The constitutional balance seemed stable, but constitutional provisions often reveal unexpected meanings when political circumstances change. What changed after the emergency? The emergency fundamentally altered the judiciary's institutional memory. The supersession of senior judges in 1973, the experience of ADM Jabalpur, political pressure during the emergency, all of these events produced one lasting concern inside the judiciary. What happens if future governments attempt to influence judicial independence through appointments? The question was no longer theoretical. History had demonstrated that constitutional institutions could become vulnerable. Judicial independence suddenly acquired practical urgency, not because judges desired institutional power, but because they feared institutional dependence. In 1981, the Supreme Court heard a case that appeared technical, S.P. Gupta versus Union of India. Today it is known as the first judges case. The issue was deceptively simple. When appointing judges, whose opinion should prevail, the executive or the Chief Justice of India? The court answered in favor of executive. It held that the government possessed primacy in appointments. Consultation did not mean concurrence. From a democratic perspective, many considered this reasonable. Governments are elected. Appointments involve public institutions. Why should unelected judges possess the decisive voice? The constitutional debate appeared settled. It wasn't. A little more than a decade later, everything changed. Advocates of Nicol Association versus Union of India, 1993 case, the Supreme Court reconsidered its own interpretation. This time, the court reached the opposite conclusion. It held that judicial independence formed part of the Constitution's basic structure. If judicial independence is part of the basic structure, then judicial appointments cannot be dominated by the executive. The court concluded that the opinion of the Chief Justice of India, formed collectively with the senior judges, would enjoy primacy. In one judgment, the constitutional balance shifted dramatically. The judiciary had effectively reinterpreted Article 124. A new institution emerged. The collegium system. Notice something extraordinary. The word collegium does not appear anywhere in the Constitution, just as basic structure is absent from the constitutional text. So too is the collegium. Both emerged through constitutional interpretation. This is one reason these doctrines remain deeply debated. Now, what is the collegium? Let's simplify it. Imagine a company, instead of a board appointing the chief executive, the existing senior executives collectively recommend who should join the leadership. That recommendation normally prevails. The collegium functions somewhat similarly. For appointments to the Supreme Court, the Chief Justice of India consults the senior most judges. Together, they recommend appointments and transfers. The government may raise objections, it may seek reconsideration, but if the collegium reiterates its recommendation, Constitutional Convention requires the appointment to proceed. This system is highly unusual. Very few constitutional democracies operate exactly this way. Supporters view it as essential. Critics view it as problematic. Both sides present serious constitutional arguments. Now, supporters begin with one principle: judicial independence. Imagine a government able to appoint judges entirely according to political preference. Would judges feel equally free to invalidate government action? Would citizens trust constitutional adjudication? Would opposition parties believe constitutional disputes receive impartial hearings? Supporters argue that independence requires institutional insulation. Judges must decide cases without fear of political retaliation. Appointments therefore require significant judicial participation. Otherwise, the executive might gradually shape the judiciary according to political convenience. History from several countries demonstrates that such concerns are not imaginary. Institutional independence often weakens gradually. Appointment processes become one mechanism through which influence expands. The collegium, supporters argue, reduces that risk. Critics respond with an equally important question: who holds the collegium accountable? The executive answers to Parliament. Parliament answers to elections. Judges answer through constitutional reasoning. But who reviews judicial appointments? The criticism is not necessarily about judicial integrity. It concerns institutional transparency. Collegium meetings traditionally occurred behind closed doors. Reasons for selection were not always publicly explained. Names appeared, names disappeared, recommendations changed, transfers occurred from the outside. The process often appeared opaque. Critics argued that a constitutional democracy should not operate one of its most important appointment systems without greater transparency. Some even described the collegium as judges appointing judges. Supporters rejected that characterization as simplistic, but the criticism continued growing. In 1998, the President sought the Supreme Court's opinion. Could the collegium consist only of the Chief Justice? The court answered no. The process required broader judicial consultation. The collegium expanded. The institutional framework became clear. By now, three landmark judgments had fundamentally rewritten the constitutional understanding of judicial appointments. Without a single constitutional amendment, India had developed an entirely new constitutional convention. But the story wasn't over. In fact, the biggest confrontation was still ahead. Fast forward to 2014, a newly elected government enjoyed a decisive parliamentary majority. Soon afterward, Parliament passed the 99th Constitutional Amendment. Alongside it came the National Judiciary Appointment Commission Act, or simply NJAC. Its objective was straightforward: replace the collegium. The proposed commission would include the Chief Justice of India, two senior judges, the Union Law Minister. Two eminent persons, supporters, celebrated the proposal. They argued it introduced transparency, broader participation, democratic accountability, a better balance between institutions. Many believed the long running controversy had finally been resolved, that the matter reached the Supreme Court, exactly as major constitutional disputes usually do. The challenge before the court was historical. Could Parliament, through a constitutional amendment, replace the collegium, or would doing so damage judicial independence, which had already been recognized as part of the basic structure? Notice how history had come full circle. Once again, the basic structure doctrine stood at the center of constitutional conflict. The very doctrine created in Keshavananda Bharati decades earlier would now determine the future of judicial appointments. In 2015, by a majority of 4 to 1, the Supreme Court struck down the 99th Constitutional Amendment and the NJAC Act. The court held that judicial independence forms part of the Constitution's basic structure. Any appointment mechanism substantially compromising that independence would therefore be unconstitutional. The collegium survived. But the court also acknowledged that the existing system required improvement. Transparency, objective criteria, institutional reform, these concerns remained legitimate. The debate therefore continued, not over whether reform was necessary, but over how reform should occur. Now let's discuss why this matters so. At first glance, judicial appointments seem unrelated to political crisis. In reality, they influence every constitutional controversy. Because before the Supreme Court decides questions relating to Article 370, electoral bonds, governor's power, president rule, anti-defection, privacy, citizenship, federalism, reservation, election disputes, someone must first become a Supreme Court judge. Institutional design therefore shapes constitutional outcomes long before individual cases arrive. This is why governments care deeply about judge appointments, why the judiciary protects independence so strongly, why constitutional lawyers follow collegium resolutions carefully. This is not merely about personal, it is about preserving constitutional equilibrium. Step back for a moment, look at everything we have covered so far. Parliament sought broad amending powers. The Supreme Court developed the basic structure doctrine. The emergency tested constitutional liberty. Public interest litigation expanded constitutional access. Judicial appointments became a constitutional battleground. Different decades, different governments, different controversies. Yet every conflict revolves around one underlying question: how much power should any institution possess? That, more than anything else, is the story of the Indian Constitution. Not the struggle between good institutions and bad institutions, but the constant effort to prevent any institution from becoming constitutionally unrestrained. And that brings us to another transformation, because by the early 21st century, the Supreme Court was no longer merely deciding constitutional disputes. It had become the arena where India's most politically explosive controversies were increasingly resolved. Article 356, coalition governments, floor test, governors, election commission decisions, anti-defection disputes, constitutional amendments, citizenship, electoral finance, federal conflicts, one by one. They all arrived before the same institution. The question is no longer whether politics reached the Supreme Court. The question is, why does almost every political crisis eventually becomes a constitutional case? That pattern is where the modern story truly begins. Let's discuss the next part: why every political crisis now ends in the Supreme Court. The Supreme Court has become India's fourth political arena. Let's conduct a simple experiment. Close your eyes and think about the biggest political controversies India has witnessed over the last 25 years. Article 370, electoral bonds, Maharashtra government formation, Arunachal Pradesh, Uttarakhand, Delhi versus the Lieutenant Governor, anti-defection disputes, Governor's power in the Tamil Nadu, Aadhaar project, the Citizenship Amendment Act, reservation policies, NEET, election commission appointments, farm laws, the demonetization challenge. Now ask yourself one question. Where did all these political battles eventually arrive? Not parliament, not political rallies, not television studios, the Supreme Court. Different governments, different chief ministers, different political parties, different constitutional provisions. Yet, every road somehow leads to one building on Tilak Marg. That cannot be accidental. It is structural. The Supreme Court has become India's constitutional battlefield because modern politics has become constitutional politics. And understanding that transformation is the key to understanding 21st century India. What are the four arenas of power? Most people think politics is fought in only one place, elections. That is only the first battlefield. Modern constitutional democracies actually generate through four interconnected arenas. The first arena is electoral politics. This is where governments are elected, manifestos are debated, campaigns are fought, public opinion is formed. This arena answers one question: who will govern? The second arena is parliament. This is where laws are debated, budgets are passed, questions are asked, committees function, government is held politically accountable. This arena answers another question: what laws should govern the country? The third arena is the executive. Policies are implemented, bureaucracies function, taxes are collected, foreign relations are managed, the military operates, schemes reach citizens. This arena answers a practical question: how should the country be administered? But there is a fourth arena, one that becomes active only when the first three disagree: the Constitution, represented institutionally by the Supreme Court. This arena answers an entirely different question: are all these actions constitutionally permissible? That is why political disputes become constitutional disputes, not because judges want power, but because the Constitution required someone to answer the final question. Here is something fascinating. Every government believes it has a democratic mandate, and usually it does. A party wins elections, forms government, implements promises. That is how democracy works. But constitutional democracy introduces another layer. Winning an election gives you authority. It does not give you unlimited authority. Imagine Parliament passes a law saying newspapers may be criticized the government only after obtaining prior approval. Suppose the law receives overwhelming parliamentary support. Would it become constitutional? No. Imagine Parliament abolishes judicial review. Imagine Parliament postpones elections indefinitely. Still unconstitutional. Why? Because elections do not replace constitutional limitations. They operate within them. This distinction is perhaps the most misunderstood feature of Indian democracy. Governments derive legitimacy from elections. Constitutions derive legitimacy from the people themselves. Those are related ideas, but they are not identical. Political parties gradually understood something important. Losing in parliament no longer meant losing permanently. Suppose the government commands a parliamentary majority. The opposition cannot stop legislation politically, but it can challenge legislation constitutionally. Now consider the government. Suppose it wins an election with a strong mandate. Passing legislation is only the first step. The legislation must also survive constitutional scrutiny. Therefore, modern political strategy requires two victories: a political victory and a constitutional victory. That is why every major political party today maintains teams of senior constitutional lawyers. Every important legislative proposal undergoes constitutional examination. Every ordinance is legally scrutinized. Every politically sensitive decision anticipates judicial review. Politics and constitutional litigation have become inseparable. The transformation occurred simultaneously. Governments became larger, much larger. The Indian state today regulates areas unimaginable in 1950. Digital privacy, artificial intelligence, finance, technology, environmental protection, national security, telecommunication, data governance, biometric identification, election funding, internet shutdown, social media regulation, climate policy, corporate governance, public health. Every one of these subjects intersects with constitutional rights, which means every one of them may eventually reach constitutional courts. As government expands, constitutional litigation expands. This is not judicial ambition, it is constitutional mathematics. More governance inevitably creates more constitutional questions. Take the office of governor. For decades, most citizens paid little attention to Raj Bhavans. Then coalition politics transformed everything. Unassemblies became common. Governments collapsed. Legislators defected. Political alliances shifted overnight suddenly. Governors began making decisions that could determine that who formed governments. Whom should be the governor invite first? The largest party, the largest alliance, a post-election coalition. How long should a government receive to prove its majority? Should a floor test occur immediately? Can the governor refuse ministerial advice? These questions are not political alone, they are constitutional. Therefore, they inevitably reach the Supreme Court. Notice the pattern. Politics creates uncertainty. The Constitution supplies principles. The court interprets those principles. Perhaps no constitutional provision illustrates this transformation better than Article 356, President's Rule. Originally, the framers expected it to remain exceptional, a constitutional safety valve. Instead, for decades it became a political instrument. State governments were repeatedly dismissed, often after changes at the center. The constitution permitted intervention, but when exactly? Who decides whether constitutional machinery has genuinely failed? Eventually, the Supreme Court answered. In the landmark S.R. Bommai judgment, the court fundamentally reshaped the constitutional understanding of Article 356. The judgment did not abolish President's rule, it constitutionalized it. The court held that the President's satisfaction was not beyond judicial review and emphasized that a legislative majority should ordinarily be rested on the floor of the House rather than decided through political assumptions. That one judgment transformed Indian federalism. Today, every discussion about President's rule begins with constitutional doctrine, not merely political preference. Now observe another interesting trend. Constitutional benches are hearing increasingly political questions. Article 370, electoral bonds, the powers of Lieutenant Governor in Delhi, the validity of constitutional amendments, reservation, citizenship, governor power, election commission appointments. The court is not seeking these disputes. The disputes are seeking the court. Because the constitution has become the common language through which political disagreement is resolved. This phenomenon has a name: constitutionalization of politics. Politics increasingly speaks the language of constitutional law. There is another reason the Supreme Court occupies such a central place today: television. Then social media, constitutional hearings are no longer hidden inside law reports. They unfold before the nation. Every observation becomes breaking news. Every constitutional question trends online. Every interim order shapes political narratives. Sometimes a single sentence spoken during a hearing dominates public debate for an entire day. This has transformed constitutional litigation. Law is no longer confined to lawyers. Constitutional arguments have entered public consciousness. Citizens now discuss federalism, judicial review, basic structure, and Article 32. These were once topics primarily for constitutional scholars. Today, they appear during prime time debates. Whether that development strengthens constitutional culture or oversimplifies complex legal questions remains open to debate. But one fact is undeniable. The Supreme Court now occupies an unprecedented place in India's political imagination. There is, however, a serious danger. Many people now expect the Supreme Court to resolve every political problem. That expectation misunderstands the Constitution. The court cannot create political consensus. It cannot govern, it cannot negotiate coalition agreements, it cannot replace parliament, it cannot substitute elections. Its role is narrower and more profound. It asks only one question: has the Constitution been respected? Sometimes that answer favors the government, sometimes the opposition, sometimes neither. The court's constitutional legitimacy depends upon remaining faithful to constitutional principle, not a political popularity. That distinction is essential. Otherwise, and every favorable judgment becomes ideological. Constitutional democracy cannot survive that mindset. By now, one pattern should be obvious. The Supreme Court has not become politically important because judges suddenly became more powerful. It has become politically important because the Constitution governs increasingly complex political realities. Modern governance creates constitutional disputes. Constitutional disputes require constitutional interpretation. Constitutional interpretation belongs to the judiciary. The logic is almost unavoidable, but this raises another question, a more uncomfortable one. If the Supreme Court now decides questions affecting governments, parliament, governors, election commissioners, constitutional amendments, and federal relations, has the court itself become too powerful? Some scholars say yes. They argue India is moving towards what political scientists call a juristocracy, a system in which judges increasingly shape public policy. Others strongly disagree. They argue the court is merely performing the role assigned to it by the Constitution. Who is right? To answer that, we must examine perhaps the most controversial debate in modern constitutional law. Not whether the Supreme Court protects democracy, but whether the Supreme Court has become one of the most powerful political institutions in India. That debate begins next. Judicial activism, judicial restraint, and the battle for India's constitutional soul. Let's begin with a question that divides constitutional scholars around the world. Imagine Parliament unanimously passes a law. The Prime Minister supports it. The Cabinet supports it. Both houses approve it. The President gives assent. The law comes into force. A few months later, 5 judges hear a constitutional challenge. After weeks of arguments, they strike the law down. Now ask yourself, who really had the final word? Parliament or the court? That question has haunted every constitutional democracy for more than 2 centuries. The United States has debated it since Marbury versus Madison. Germany has debated it after the Second World War. Israel debates it almost every year. The United Kingdom debates it differently because of parliamentary sovereignty. India debates it perhaps more intensely than almost any other democracy because our constitution creates an unusual balance. Parliament is powerful, the executive is powerful, the judiciary is powerful, yet none of them is supreme. Only the constitution is. The real question, therefore, is not whether the Supreme Court has become powerful. The real question is this: has the court begun exercising power that the Constitution never intended it to possess? What is judicial activism? The phrase is used constantly, usually without definition. So let's define it carefully. Judicial activism does not simply mean striking down laws. That has always been part of judicial review. Instead, judicial activism refers to situations where courts interpret constitutional provisions broadly, sometimes filling gaps left by the legislature, sometimes directing governments to act, sometimes creating constitutional principles not expressly written into the statutory law. Supporters call this constitutional evolution. Critics call it judicial legislation. The difference often depends on where one stands politically. But constitutional analysis demands something deeper. We must ask, why did judicial activism emerge in India? The answer lies not inside the judiciary alone. It lies inside the failures of other institutions. Imagine a river so polluted that millions lose access to clean water. The government delays action for years. Parliament debates the issue endlessly. Administrative agencies fail. Citizens approach the Supreme Court. Should the court refuse to intervene because environmental policy belongs to the executive? Or should it protect Article 21 by directing governmental action? Now, Imagine thousands of prisoners remain in jail without trial. Should judges simply wait, or should they interpret the constitution to protect liberty? Imagine a widespread sexual harassment at workplaces before Parliament enacted comprehensive legislation. Should the court remain silent, or should it establish temporary constitutional guidelines? These are not hypothetical questions. The Supreme Court answered them repeatedly. The Vishaka Guidelines emerged because Parliament had not yet enacted a statutory framework addressing workplace sexual harassment. Environmental jurisprudence expanded because regulatory enforcement often proved inadequate. Police reforms reached the court because governments repeatedly delayed implementation. Time after time, the judiciary entered spaces left vacant by institutional inaction. Supporters argue this was constitutional necessity. Critics argue necessity gradually became habit. Now let's examine the opposing view. Suppose judges begin deciding where highways should be built, how buses should operate, which administrative officer should be transferred, how many schools should be opened, what environmental policy should look like in technical details. At what point does constitutional review become governance? That is the central criticism of judicial overreach. Courts possess legal expertise, governments possess administrative expertise, judges hear evidence, executives implement policy. The Constitution intentionally separates these institutional functions. Why? Because each institution develops different capabilities. Parliament debates competing interests, governments allocate budgets, civil servants administer programs, court interpret laws. When one institution performs another function, constitutional balance becomes difficult. This criticism deserves serious consideration because constitutional democracy depends not only upon active institutions but also upon restrained institutions. Here's everything often overlooked. The Constitution never assumes institutions will perform perfectly. Governments make mistakes. Parliament passes unconstitutional laws. Courts occasionally deliver flawed judgments. Election authorities face difficult choices. Governors sometimes exceed constitutional boundaries. The Constitution anticipates human imperfection. That is why it distributes power, not because every institution is always right, but because no institution should possess unchecked authority. Checks and balances exist precisely because constitutional designers distrusted concentrated power. That distrust includes judicial power itself. The court's greatest strength and its greatest weakness. The Supreme Court enjoys enormous constitutional legitimacy, but it also possesses an important limitation. Unlike governments, it cannot choose its own cases. Cases arise because citizens file petitions. Governments challenge each other. Political parties litigate. Constitutional authorities disagree. The court reacts. It does not initiate constitutional controversies. Constitutional accountability weakens. This phenomenon has another name: constitutional dependency. And constitutional democracies should avoid it. Many viewers become frustrated when the Supreme Court declines to hear certain political disputes immediately. Some interpret delays as weakness, others interpret restraint as bias. Often, the explanation is constitutional. Courts recognize doctrines such as ripeness, mootness, alternative remedies, political questions in limited context, institutional competence, constitutional timing matters. Some creates greater constitutional confusion. Sometimes delayed intervention protects institutional legitimacy. Judicial restraint is not always judicial avoidance. Occasionally, it is constitutional wisdom. Think carefully about this. The Supreme Court has no electoral mandate, no military, no police, no budgetary control over governance, no taxation power, no administrative machinery. Its judgments are obeyed because society accepts constitutional legitimacy. That legitimacy rests upon one fragile foundation: public confidence that the court decides according to constitutional principle, not political preference. The day that confidence substantially erodes, the court's authority weakens regardless of constitutional text. This is why reasoned judgments matter. Transparency matters, institutional integrity matters, independence matters. Not because judges seek prestige, but because constitutional legitimacy cannot be manufactured. It must be earned repeatedly, judgment after judgment, generation after generation. After everything we have examined, perhaps we can finally answer the question: has the Supreme Court become too powerful? The answer depends on what you mean by power. If you mean the ability to govern, no. Governments still govern. Parliament still legislates. Citizens still elect representatives. If you mean the ability to define constitutional limits, yes. But that authority comes directly from the constitutional structure itself. The court has become central because modern politics increasingly involves constitutional questions. The constitution expanded in practical significance. The court necessarily expanded with it. The real issue, therefore, is not excessive judicial power. It is maintaining constitutional balance, enough judicial strength to protect constitutional limits, enough judicial restraints to respect democratic choice. Finding that balance remains one of the greatest constitutional challenges facing every democracy, including India. We have now answered almost every major question: why political crisis reached the court, how the basic structure doctrine emerged, why judicial review matters, how PIL transformed constitutional litigation, why judicial appointment became controversial, why the court appears politically central. But one final mystery remains, perhaps the biggest of them all. If the Supreme Court protects the Constitution, who protects the Supreme Court? Not from criticism. Criticism is essential in a democracy, but from political capture, institutional decline, loss of public confidence, and constitutional irrelevance. Because history teaches one final lesson: constitutions do not survive because they are written, they survive because institutions remain worthy of the trust placed in them. That is where our story reaches its final chapter. Not about judges, not about politicians, not even about the Constitution itself, but about something far more important: the constitutional culture that ultimately decides whether democracies endure or merely exist on paper. The next part of this lecture is about who protects the Constitution, the future of the Supreme Court, democracy, and India's constitutional culture. After nearly 75 years, India has held regular elections. Governments have fallen, prime ministers have changed, political parties have risen and disappeared, wars have been fought, economic systems have transformed, technology has rewritten everyday life, social movements have altered public morality. Yet one document has remained remarkably constant: the Constitution. Not because it never changed, it has been amended more than 100 times. Not because judges interpreted it identically, they did not. Not because politicians always respected it. History tells us otherwise. The Constitution survived because institutions kept pulling India back toward constitutional order. That raises one final question, the most important question in this entire series: who actually protects the Constitution? Most people immediately answer: the Supreme Court. The answer is only partially correct. It depends upon one institution alone. Then the Constitution is already weak. The real guardian of the Constitution is much larger than the Supreme Court. It is India's constitutional culture. A constitution is only a paper. Imagine two countries, both adopt identical constitutions. Every article, every provision, every amendment, every institution, everything is exactly the same. Now imagine 20 years later, one country has become a stable democracy. The other has descended into authoritarianism. How is that possible? Because constitutions do not enforce themselves. Human beings enforce them. Judges, politicians, civil servants, police officers, journalists, lawyers, teachers, universities, citizens. The Constitution is not a machine, it is shared agreement about how power should behave. Without that agreement, constitutional text becomes symbolic rather than effective. History proves this repeatedly. Many authoritarian regimes possessed beautifully written constitutions. Some even guaranteed passive fundamental rights. The words existed, the constitutional culture did not. On 25th November 1949, one day before the Constituent Assembly adopted the Constitution, Dr. B.R. Ambedkar delivered one of the most remarkable speeches in Indian political history. He issued a warning that remains astonishingly relevant. He said that however good a constitution may be, it will be turn out bad if those called upon to work it happen to be bad. And however bad a constitution may be, it may turn out good if those called upon to work it happen to be good. Notice what he was saying. The success of constitutional government depends less upon the constitutional design, but more upon constitutional character. No document can permanently compensate for institutional failure. No country, no court can permanently rescue political irresponsibility. No amendment can permanently replace constitutional morality. That responsibility belongs to society itself. There is a constitution everyone can read, the written constitution. Then there is another constitution, the invisible constitution. It consists of habits, conventions, institutional respect, political restraint, acceptance of adverse judgments, peaceful transfer of power, respect for opposition, acceptance of electoral defeat, protection of minorities, administrative neutrality. None of these principles operates solely because an article commands them. They operate because constitutional culture expects them. The written constitution tells us what institutions may do. The invisible constitution tells us what institutions ought not do. Even when technically they can, the health of a democracy depends upon both. Many people believe that whenever democracy faces difficulty, the Supreme Court should intervene. That expectation misunderstands constitutional design. Consider this: suppose Parliament repeatedly passes unconstitutional laws. The Supreme Court repeatedly strikes them down. Has democracy become stronger? Not necessarily. It may actually indicate that another institution is weakening. Or imagine governments repeatedly ignore constitutional conventions. The court intervenes each time. Again, the judiciary appears active. But constitutional culture becomes increasingly dependent upon litigation because courts constantly rescue them. Healthy democracies function because rescue becomes unnecessary most of the time. The strongest constitutional systems are those where litigation becomes the exception, not the governing method. Now let's talk about the responsibility of Parliament. Parliament possesses responsibilities extending far beyond legislation. It represents democratic legitimacy, public debate, political accountability, national consensus. Its duty is not merely to pass laws, it must also protect constitutional values while doing so. A parliamentary majority is extraordinarily important. But constitutional democracy requires something more. Majorities must govern, minorities must remain protected, opposition must remain legitimate, debate must remain meaningful. These are not judicial responsibilities, they are parliamentary responsibilities. When Parliament performs them well, constitutional conflict naturally decreases. What is the responsibility of the executive? Governments often focus upon efficiency, implementation, delivery, administration. These are essential, but constitutional government requires another quality: restraint. Every executive possesses immense power. Police, taxation, investigation, administration, appointments, emergency powers, regulation, because the executive interacts with citizens more than any other institution. Its constitutional discipline matters enormously. Most constitutional crises do not begin inside courtrooms. They begin inside administrative decisions, long before judges become involved. What is the responsibility of judiciary? The judiciary also carries constitutional obligations. Independence alone is insufficient. Independence without accountability risks isolation. Authority without transparency risks mistrust. Judicial courage remains essential, so does judicial humility. The Supreme Court must remain strong enough to protect constitutional limits, yet restrained enough to respect democratic choices wherever the Constitution permits them. This balance is extraordinarily difficult. Every Chief Justice, every Constitution bench, every generation of judges confronts it anew. There are no permanent answers, only continuing constitutional judgment. So, what is the responsibility of lawyers? Here, I want to pause on one institution that rarely receives sufficient attention: lawyers. The Constitution speaks through advocates before it speaks through judges. Every constitutional doctrine, every landmark judgment, Every historical precedent began as an argument presented by someone standing before the bench. Think about India's constitutional history. Nani Palkiwala, Fali Nariman, Soli Sorabji, Harish Salve, K.K. Venugopal, M.C. Sitalwar. Many of the republic's defining constitutional movements were shaped not only by judges but by extraordinary advocates. The bar performs a constitutional function. Its duty is larger than winning cases. It protects constitutional reasoning itself. When advocacy declines, constitutional adjudication inevitably suffers. A great constitutional court requires a great constitutional bar. The two evolve together. So, what's the responsibility of citizens? Ultimately, the constitution belongs neither to the judges nor politicians. It belongs to citizens. Every election, every public debate, every peaceful protest, every informed disagreement, every demand for accountability, every exercise of free speech, every insistence upon due process. These are constitutional acts. Democracy does not survive because citizens occasionally vote. It survives because citizens remain constitutionally engaged between elections. That engagement must remain informed, not emotional, not partisan, constitutional, because constitutional ignorance creates opportunities for constitutional abuse. We can now finally answer the question that began this entire series. Why does every political crisis in India end up in the Supreme Court? Not because judges seek political influence, not because politicians enjoy litigation, not because the constitution is defective. It happens because the Indian constitution was intentionally designed to convert political power into constitutional responsibility. Every important political decision eventually encounters constitutional limits. Those limits require interpretation. Interpretation belongs to the judiciary. The court therefore becomes the final constitutional forum, not the final political forum. That distinction matters immensely. The Supreme Court cannot decide who deserves political victory. It decides whether political victory remains constitutionally valid. Those are profoundly different responsibilities. The constitutional questions confronting India are changing. Artificial intelligence, digital surveillance, data ownership, biometric governance, climate change, platform regulation, algorithmic discrimination, deep fakes, national security in cyberspace, space law, genetic technology. None of these subjects received detailed attention in 1950. Yet, all of them will require constitutional interpretation. The constitution will continue evolving, not because its text changes every year, but because society does. The Supreme Court will continue interpreting old principles for new realities. That is how living constitutions endure. If there is one lesson history teaches, it is this: democracies rarely disappear overnight. They either strengthen gradually or weaken gradually. The same is true of constitutional culture. Every parliamentary debate matters, every citizen matters. The constitution is not protected once, it is protected continuously. Generation after generation, that responsibility cannot be delegated. Not to governments, not to judges, not to lawyers, not even to the Supreme Court. It belongs to the Republic itself. The next time you hear that another political controversy has reached the Supreme Court, do not ask only who will win the case. Ask a deeper question: what constitutional principle is really being tested? Because behind every headline, behind every courtroom argument, behind every political crisis lies the same enduring struggle. How do free people create a government strong enough to govern, yet limited enough to remain free? That question has no final answer. Every generation must answer it again. India's constitution is not simply a legal document. It is an ongoing conversation between liberty and power, between democracy and restraint, between politics and principle. And that conversation is far from over. Thank you for watching.